So today I wanted to discuss the IP commercialization option and strategies. Every member of a Tech Tokyo has a different interest and a different way of considering IP options. So I'm going to speak generally, but I will make some examples and assumptions about how this would work for Tokyo Land Corporation. I like to start my talks with a joke or with something that allows us to think about the issue. I chose this one by Tom Fishburne because this is more or less true for almost every corporation. The hierarchical structure of just about every company and the incentives that each company has don't work for innovation too well. They're not aligned for innovation too well. In this joke, we can see the chief status quo officer to whom some VPs report, and they are wait and see, play it safe, more analysis. And then under them, there's directors that they also have their concerns. It'll never work, we tried before, yes, but. And then there's a manager which says, I give up. It is true that in organizations, the feeling, the approach, the expectations are different depending on the level of seniority and the function. One thing that is very common is that the higher ups dream of a future. The VPs are concerned about strategic implications. Then directors are concerned about tactical decisions, and then the managers have to actually implement both visions, right? The idealistic dream vision, and at the same time, the conservative, careful, risk-averse vision, and that leads to very often paralysis. So that's something to keep in mind as we discuss IP and strategies and options, because the reality of a big corporation are at the end of the day what matters. So let's talk about the theory first, but let's remember all these limitations and address them. So first, what is intellectual property and what for, and why does it matter, or it doesn't? I am a known critic of intellectual property. As a matter of fact, if you look at my name in Wikipedia, the one thing that they mention is that I'm an intellectual property critic. I've written articles about it, chapters in books. I've researched intellectual property for many years. I think in most cases, in most countries, in most laws, intellectual property is very wrong. There are exceptions where there's no better alternative yet, but in most cases, intellectual property is the wrong approach. But I'm not going to go into the details of why and the legal implications and all that. I'm going to tell you the concept, which is most people, particularly investors, see intellectual property as a moat, as this gap between a castle and a field where if somebody tries to attack, there's water, there's crocodiles or any kind of danger, so it protects the castle. So most people think of intellectual property as a protection. That has two problems. One, it isolates the castle. So it makes it more difficult to approach. And innovation cannot work in isolation. The second problem is that it creates a defensive mentality. I prefer to put the emphasis on the castle itself, in this case, the company, in this case, the product, the market, rather than a legal strategy or mechanism to keep anybody away, particularly the competition. Because in theory, in free markets, competition is good. So that's why I'm critical of intellectual property. But in any case, why does it matter? Universities are looking for knowledge impact, for funding, and for reputation. Corporations are looking to access new technologies, reduce research and development timelines, and competitive advantage. So while they might want different things, it matters to them what is the innovation matters to them and how to protect it or enhance it or facilitate it. It matters to them. One key element of this corporate university collaboration regarding intellectual property, it's technology transfer offices. They have different names. For example, at Harvard, they call it Office of Technology Development. But in any case, same concept. They identify, protect, and commercialize research discoveries. They negotiate with industry and manage the IP portfolio, always with laws and university policies in mind. So they are the most common counterpart or interlocutor for discussions around IP stemming or coming out of universities. What kinds of IP are there? So there are many kinds of IP. We always think of patents, but there are several. And it's important to know them and also to know which one to use when, if at all. The most common, like I mentioned, is patents and utility models. So utility models are a lesser version of a patent with reduced restriction, but in any case, they're in a similar category. There are many, many silly patents. I put it there, the illustration of a silly one, an umbrella to protect your drink. I'm fascinated by a concept in Japan called the Shindogu. These silly inventions that might or might not be useful. People can try to patent anything they want, and there are very clear rules and regulations on what can be patented and where. So talking in general as a concept, we have patents as the biggest, highest form of protection for intellectual property. Then we have copyright or copyleft, which I prefer. That covers different things. Copyright covers communication, covers artistic productions. Copyright covers message, unlike patents, which cover inventions. I have a 4-hour-long lecture on the difference. I will not go into those details, but I'm happy to answer questions or provide more information later. What I did want to mention is that copyright is very often abused for censorship reasons by governments, for even censorship reasons by corporations. Oftentimes, corporations use copyright to try to prevent anybody from criticizing their products or their companies. There are very extreme cases of copyright abuse. For example, the picture that you see there is a picture taken by a photographer called Ms. Highsmith. And she put all of the pictures as taken in the public domain, the Library of Congress in the United States, which means anybody can use it for any reason. Then Getty Images, which is a company that licenses photographs through copyright, took those photographs and started selling them. which they are allowed because if something is in the public domain, you can do that. But when the photographer put this picture on her website, Get the Images sued her, which is insane because it was her own photograph. There are many more examples, like taking pictures of food in Germany. If you go to a restaurant and you take a picture of a dish and you publish it on your social media, you can get sued by the chef because it's considered an artistic creation, the chef having rights to that. Even more dangerous, the laws, public laws in the state of Georgia in the United States are copyrighted. So you cannot publish those laws or access them without paying, which is, like I said, incredibly ridiculous because if the public doesn't have access to the laws, how are they supposed to know them and therefore abide to them? Anyways, those are extreme examples of copyright abuse, and there are many others. So copyright can be used, copyright has uses, but it also has abuses. Then we have a different kind, which is trademarks and registered marks. They cover identities, company identities, and different kinds of identities. For example, we all know the famous designer Karl Lagerfeld, passed away not long ago. His look, and you have a little caricature there of him and his famous cat. His look is trademark. The words, the words face, book, and home, they're trademarked by Mark Zuckerberg of Facebook, and there are the classes 935 and 38. How can you register a word? Well, they have classes, classifications, and you cannot use a specific word for a specific use if somebody has registered it, which again, I think is preposterous and ridiculous. Things like the Eiffel Tower slideshow. If you take a picture of the Eiffel Tower in Paris at night, you may not be able to use that picture. The very famous case, Apple versus Samsung, where you slide the button to unlock it. Samsung had to pay $120 million to Apple for using that feature because it was a registered feature. It wasn't patented. Again, there's, patents in the software world do not work, and they're mostly illegal in most countries, even though some companies still try to patent software, and in the United States, in some cases, they accept it, but it can be registered under, under trademark. It can be copyrighted, so something to keep in mind. And then we have trade secrets, things like the Google search algorithm, Kentucky Fried Chicken recipes with Twinkies or McDonald's sauce or Coca-Cola, the food recipes. One that is particularly surprising is the New York Times bestseller definition. What is a bestseller according to the New York Times? They have not released the information of how they get to that point, and they say it's a secret. The reason they say is because they don't want publishers and authors to abuse the system. But that takes us to the question, so how do we know that they properly collect that information if it's a secret? Another crazy example, it's Listerine, the mouthwash brand. Lambert, the inventor, and his family, when he passed away, licensed it, sold the secret to Pfizer. And then Pfizer was paying royalties. But then the secret was made public. So Pfizer sued saying, we don't need to pay royalties anymore because the secret is no longer a secret. And they lost because the judge said, well, you pay to have access to the secret and you have access to the secret. That doesn't mean that others cannot have access to the secret at the same time. Again, it makes no sense, but that's the way law is made. Or WD-40, the lubricant in the United States. They put up a show about how they keep the secret under different bank vaults, and then they move it around so nobody can see it. But that secret, that recipe for the lubricant, has been reverse engineered and is public for many years. They still do things like the CEO dresses with armor and carries the secret in a suitcase on on a horse. I know it's just a show, but oftentimes patents and different types of IP protection are just a show to make people believe you cannot access that, which makes you wonder, does that hurt the consumer? Does that hurt the marketing of the product? So those are considerations to keep in mind. In any case, most companies for research, for innovations, particularly technology ones, will be analyzing patents as a starting point for their own research or potentially for licensing. One of the roles of TechTokyo is to provide curation services by which we analyze patents and search the portfolios of universities and startups to find what inventions might be useful for our members. How do you analyze a patent? Well, there are different patent databases, all with the pros and cons. One of the most famous ones is PatentScope. So what you do or what we do, again, I am against copyright, therefore I try to not have secrets and I like to disclose how I work. So first, we go to Google Patents because it's the easiest patent search engine and it gives you particular information that is useful, but it's not the best way to analyze a patent. So we go to Google Patents, search for concepts, ideas, fields, and then we go into advanced search. We see who published the patent. We want WO or WIPO, the World Intellectual Property Organization. And they will give you at the bottom on the right column a link to PatentScope or to Global Dossier, which is what we want to use. It's important to look at specific documents that Google Patents doesn't have. So then we go to PatentScope with that link. So we go straight into that patent. In the case that you can see on the screen is about polymer encapsulated drug particles. Fine. On the right, we have a number of documents because when you file for a patent, you have to provide certain documents, and when they reply, they have to provide certain documents. So you go to the documents and you download the PDFs. Which ones? The most important ones are ISA 210, so International Search Report, which contains a table with the relevant prior art documents, so anything before that patent that might affect patent defensibility or might be related in the research, and ISA 237, which is the written opinion of the International Searching Authority. Because in that written opinion, you can find their analysis of whether the claims are new and non-obvious, which is inventive, including the box V section, which is they have details of the claim. So N for novelty, IS for inventive step, IA for industrial applicability. And those are the key elements that you want to look and see, is the patent any good? Is this really new? Is this just incremental? Can this be applied in the industry? And then, a brief explanation. So that's one way to dig deep into a patent. You need some knowledge of the field you're looking at, but this allows you to not be a deep expert and yet get a good sense. Then for universities, we will use a different database, a University Intellectual Property. We will use another one called Global Data. So Global Data has modules, and you go to the patent module. In the patent module, after you do a search, you go into focus. So you want to look, for example, cardiovascular area. And then they have something really interesting, which is the score calculation. They tell you how they come up with specific scores. So there's a number of parameters, many parameters, as you can see in the image on the right. And the interesting thing is that you can change the parameters to affect the calculation. So if you're very interested in industrial applicability, you give that parameter a bigger weight, more importance. If you are interested in novelty, you give that one more weight so that those patents that fit that criteria, your criteria, show up higher in the search or with a bigger score. So that's a very quick overview of how we review patents and how a company's research and development division can leverage existing public information, which is, at the end of the day, one of the only good things about patents is they have to be published. So therefore, it's public information. But searching and filtering, it's quite challenging. So I hope that walkthrough was useful. So this talk was also about strategies. What are the strategies? What are the mechanisms for a corporation to leverage a university-derived intellectual property? There are many ways. The most common one is in licensing, where a company licenses the intellectual property of a university. The license can be exclusive or it can be non-exclusive. So exclusive only to your company, or non-exclusive, you get the right to use that technology, but others do too. The Office of Technology Development, Office of Technology Transfer, they have patent portfolios. They have a number of patents. You need to reassess them and evaluate them because there are changes to those IPs. So we provide our members a list of curated intellectual property opportunities. That doesn't mean that we will not review that list. That doesn't mean that we will not look again. That's why there are regular meetings, because things need to be reassessed. Another common way to engage university intellectual property is through sponsored research, material transfer agreements, and collaborative research and development. Things to keep in mind is that in those cases, you need to define intellectual property ownership, who will get the rights to what. Publishing rights, at the end of the day, academics are very interested in publishing, but depending on the type of the intellectual property, that may or may not mean there is a challenge with publishing certain information. For example, if you are paying for research, but you don't want some details of that research to be made public because you want to be the first one to know that, then you don't want that to be published. But at the same time, academics research to publish. So those things need to be discussed. Then, which commercialization routes to use, it's also important. Who is going to sell what? That it's clear for the company. The company knows what it wants to do with the IP commercially, but sometimes universities or academics have a little bit of a concern, depending on the company's reputation, depending on the intention of commercializing, etc. A clear example, easy one, is when a pharmaceutical company wants to license a compound, a molecule to create a medication, a drug, but the pharmaceutical company wants to make that drug very, very expensive, so only a few patients will benefit, but they will make a lot of money. Very often researchers don't like that because they want to help many people, not just become rich. So those are things that need to be discussed. Then another option is a joint venture or shared intellectual property. That allows for deeper collaboration, for pooling the talent, so bringing the talent together and the resources which accelerates the technology maturation, the speed at which the technology becomes viable for market, and the market entry. Those are more complicated because it's creating a new entity, a new company, or exchanging ownership of a company, or sharing, co-owning an IP, and that legally is a lot more complex, but it's another option to consider. That is particularly true for very complex research. And then you have the option of open innovation or open material transfer agreements, where through mechanisms like patent pools, cross-licensing, or consortia, multiple parties can innovate, and that is important for things like interoperability or standards. There are fields like healthcare or information technologies, information and communication technologies, where multiple elements interact, machines and software, connections. So oftentimes you need different companies and different researchers working together, or else it's impossible to make progress. So that's another option. What are the challenges and what are the key negotiations to keep in mind for collaborating with a university, with a researcher, with a lab, and a company? So the challenges are, like I mentioned, different objectives. One wants publication, but the other one was secrecy. The timelines, the speed, the speed at which academics move is not the same as the speed at which corporations want to move. And the speed at which a corporation moves is not the same as the speed as a startup can move. So that's very, very important. Then the evaluation of the IP. How much is it worth to each party based on what method to do the evaluation? And then the differences, the cultural gaps, the things that we are not seeing about the other party, how do they operate? How do they think? What do they want? It's important to keep in mind. For negotiation, we need clarity on the agreement, on the contract, and we need clarity on royalties. They can be fixed or they can be tiered. Equity, particularly when we're dealing with startups or with joint ventures. Performance milestones, which milestones are going to be agreed on so that they make a change in the next step. The upfront fees, who's going to pay for what? The diligence obligations, who's going to do which step, particularly when it comes to legal steps or registration steps. And then sub-licensing. Can the company license that IP to another company? Sometimes that's not their intention, but what happens is that the mother company, the holding company, signs an agreement, then a subsidiary is the one using the IP, but legally they might not be the same and that might not be covered. So even in those cases, that needs to be specified. Then we have to manage risk. Like I mentioned, academics are concerned about reputational concerns and the freedom to publish. But also the company wants to protect confidentiality and the competitive edge. So everybody has to manage that risk. That's an important aspect that we manage through TechTokyo. We get to know the companies, we get to know the researchers, and we only bring them together if we see there is not a significant risk, if we see that there is a significant alignment. Otherwise, it's a waste of time. Then we have the legal and regulatory aspect, of course, because the laws are different regarding intellectual property. ownership, employee inventions, export controls. There are many elements that are very important to keep in mind when drafting one of these agreements. Of course, you need a lawyer for this. So the legal department, the general counsel will review, but those are things to keep in mind. And then when the deals are cross-border, they're international, you also have to check for not just legal compliance, but also for regulatory compliance. The Bayh-Dole Act in the United States, GDPR in the European Union. So those are examples of things to keep in mind. Finally, something to remember, which in the case of a corporation is usually not top of mind, but in the case of universities is always fundamental, is the funding model. So there are many funding models. The government can give grants, non-dilutive funding. Venture capital or corporate venture capital can provide funding. It can be an industry sponsor where the corporation pays. It can be philanthropic venture where a philanthropist or philanthropic foundation provides funding for this research or this commercialization to move forward. So while, again, in a corporation, the default is, well, we're going to use our own funds, obviously, it might be worthwhile to consider options because there might be other options out there. Now, what about the strategies with startups? It's a complete different world. The types of collaboration could be similar, but there are many others. So obviously, you have in-licensing, like with the universities, but you also have out-licensing. You could license the technology from the corporation to the startup. You can pilot one of their products. I think this is one of the main collaboration methods for Tokyo Land Corporation, for example, where you own buildings and you own infrastructure that could benefit from inventions from startups, and where you could put those inventions to pilot, to test. Companies that have consumer products have a bigger challenge in piloting because the brand reputation is distributed amongst all the consumers. But companies like Tokyo Land Corporation, where the infrastructure and the assets are big and concentrated, those are easier to, they have an easier time to pilot. Another one for industrial corporations is to prototype, manufacture the first units for the startups. Testing, obviously, distribution agreements, that could be co-branding, obviously investment or acquisition of the startup. So there are many more options than the typical options with universities. But there are things to be considered, things that are important. One is the alignment of expectations and the modus operandi, which is how do each other work? How does the startup work? How does the company work? And align the expectation. Let's agree on timelines. Let's agree on communication. Let's agree on how to do this. That is the number one reason why these collaborations fail, is not understanding how they work. So that's why I added there empathy. It's not just telling the other, you're the corporation and you tell the startup, we want a quarterly meeting. And the startup says, oh, but we do weekly meetings or daily meetings. It's not only establishing, okay, let's do one every 2 weeks. It's also understanding why. The corporation has more people, and therefore information is more complex, and therefore they need more time to do things. Startups are more nimble, they can move faster, therefore they can do things at a shorter timeline. Understanding that helps you put yourself in the shoes of the other party, understand how they do things, and therefore it's easier to reach a compromise that works for both, not to force or impose a way of doing things onto the other. So what are the best practices? What's the advice for licensing IP, for doing sponsor research, for working with startups. One is early alignment of goals. Talk about the goals as early as you can. What is it that we are trying to achieve out of this? And be extremely transparent. Keeping things generic and abstract doesn't help reach agreements. You have to be very specific. You can be as specific as saying, we want to license this patent so we can manufacture this product, put it in the market in 6 months at this price point so we can make this much money in revenue. That is being specific. If you say, oh, we want to license this patent because it's very interesting, that doesn't help anybody reach an agreement. You should also request the other party to be specific and tell you their goals. Say you're talking with a lab director, a head researcher, and they tell you, we want to publish as many papers as possible. That's very different from, we want you to sell as many products derived from our patent as possible, so we make as much money as we can. See, those are very different objectives. There is nothing wrong with either of those, but it is important to know because that may affect the agreement and the details in the legal document. Things to keep in mind also when thinking of goals, it's people, not just objectives. So sometimes people want dual career tracks. Maybe the researcher would like to work part-time for the corporation. Maybe the corporation wants to send one of their researchers to the lab. There are entrepreneurship training. Sometimes researchers get excited about working with companies and they want to learn more about the commercial world. And the rewards for translational impact. Sometimes universities reward through tenure track or through different mechanisms those who license their intellectual property, and therefore that's an incentive that is beyond your agreement, but that could benefit them. Another best practice is clear communication and defined roles. This is very important. The knowledge economy is based on information. So having a single source of truth, meaning having a single place where we all agree the information is located, it's important. If everybody keeps copies of different files and different versions and different computers, there's going to be misunderstandings, there's going to be mistakes. So setting up a data room or setting up a share drive or whatever mechanism for these discussions, it's very important so that there's no misunderstandings. Generally, lawyers know this very well. They insist on following proper procedure, but sometimes discussions start before engaging any lawyer, and therefore there might be misunderstandings early. So it's good to keep this in mind from the very beginning. Also, limited channels. If you have conversations via emails, video conferences, instant communication like WhatsApp or Line, if you use many channels and many communication mechanisms, it's more likely that some information is going to be lost. For example, at Tech Tokyo, we set up the members portal so that we have a single source of truth and the main information is located in the same place, and we send emails. Of course, we have conversations, of course, we have meetings, but we like things to be in writing. That way we can search for information and find out who said what when, makes things easier. And then the public role and the status. We need to know who does what when, and that can change, and that's okay. Generally, that changes more often in corporations than in academia. Academics progress through their career slowly. So the head of a laboratory, the director of a laboratory, might move to a different university, but it will always be director of the laboratory, unless the laboratory runs out of funding and they close down. But in corporations, people move through different roles and they change. So if the other party, the other side, doesn't know who the executive in charge of the discussions is, who the person in charge of research and development is, because they might have changed, that can be a big problem. So in that single source of truth, in that single location of documents, a place where the roles are clearly defined, that can be updated quickly, it's important. That way we can always check and say, oh, I was talking with Mr. Takahashi, but Takahashi-san is no longer the head of research and development. Now it's Yamada-san. So I check, I know, and I know who to speak with. Otherwise, I could be sending emails to Takahashi-san. Takahashi-san is not responding. Then one day Takahashi-san responds, I'm not head of research and development anymore. I feel like I've been wasting time. And those things are not good. So again, clear communication, define roles. Another important best practice is transparent processes and regular progress reviews. Both sides need to know what the steps are going to be. Both sides need to be able to review those steps. So from day one, you agree, okay, we will have a monthly meeting, or we will send an email report every week, or whatever it is. And then everybody, both sides, have to be able to review and say, well, let's reconsider this. This is not quick enough. Or we agreed on steps number 1, 2, and 3, but we have to add a step number 4. That is important, and it's important to have a place to document all those processes. So if something fails, we can go back, check where it failed, improve it, and don't make the same mistake again. Otherwise, little mistakes accumulate, little miscommunications accumulate, and that makes people feel there is something wrong. That makes people feel the collaboration is not worth it. That makes the managers and directors and leadership feel that the collaboration is not progressing, therefore is a waste of time and resources. The collaboration might be progressing, things might be happening, but if there are communication errors, then it might give that impression. And then maybe the collaboration will not be a success because of that. So those are important parts. Another point that I would like to make, and that is not very common, but it should be, it's discussing the metrics of success. It's similar to the first one, the early alignment of goals, but how do you measure that we've achieved those goals? And the important part is quantifying the value. So in the goals, we discuss what's valuable for me as an academic, or what's valuable for me as a company executive. But how do we measure that? Do we measure just revenue? Do we measure systemic impact? How much innovation has this unlocked? how much economic growth impact on society. I am surprised, pleasantly surprised, to see that most corporations in Japan, in their vision and their goals, mention society. To improve society, to help society, to make a better world for the future. Western companies are incredibly pragmatic, transactional, materialistic. So they rarely mention society in their goals. They mention it in their SDG reports, and they don't want to come across as evil, but they do not really focus on society. But Japanese corporations seem more interested in helping society than Western corporations. It both makes me happy, and it's important to keep in mind when we analyze the metrics of success, then we should consider that. How did this collaboration help society? How did it unlock innovation, economic growth, etc.? Those are things that academics will always be happy to do. And it's something to keep in mind because, again, the point is, the challenge is how do you measure that? So agreeing on the metrics is important. That way, when we review the outcome of the collaboration, we can look at the proper metrics and not metrics that are unrelated. So what are the trends? These university corporation, startup corporation collaborations, where are they heading? Where are people doing now? Well, there are some general trends and then a caveat, a warning. The general trends are, first, there is a growing convergence of academia and industry. There is more and more collaboration. This is good. There is more open innovation, more companies are joining together, more groups, more consortia. There is increased cross-border collaboration, international collaborations. So, the globalized world, it's showing in these kinds of collaborations. And there's more focus on social impact technologies, not just commercial returns. With my previous comment about Western corporations, I must add, I did see advising hundreds of startups that in the last 2 or 3 years, there was a big increase in social impact startups. So those are the trends, but it must be mentioned that at the White House, there are reactionaries now that are pushing back against progress and against collaboration. They want to see a nationalistic world, which is fragmented, which does not collaborate, and it's only thinking about money. So the White House now is trying to push against these trends, this progress. I really think these trends cannot be turned around. I really think that the globalization will not stop. And I really think that this pushback is not going to change things. But it's something to keep in mind because it has lots of impact on export restrictions, on tariffs, on non-dilutive funding from government grants. So it is important to realize the current climate that we live in. So you have more information on our website, on our members' website. This recording will be uploaded with the transcript properly translated in Japanese. I hope the real-time translation that we've provided, it's good enough, but we will review. And we will soon send a newsletter. And of course, you can always contact us. You have our emails. You can send me an email anytime, requesting more information, details, anything. But I wanted to leave a few minutes for question and answer, and I will stop the recording here so you can share classified information or private information, and this will not leak anywhere else. Thank you very much.